So, after going through the importance of the objectives and scope of the Act, let us look into need and importance of the Act. So, as I have seen earlier, the lawmakers felt that need to make a separate enactment to deal with Lok Adalat and legal aid and legal services, and the need and importance of Legal Services Authority Act 1987 for fair administration of justice in India was highlighted by the High Court of Gujarat in Dinesh Bhai Demen Roy versus State of Gujarat. In this case, the court stated that India is the largest democratic republic which has adopted the doctrine of welfare state. Rule of law has been recognized as one of the basic features of the Indian Constitution. Almost 50% of our population constitutes women, and undoubtedly in the present social setup there is still undesirable strong gender bias in practice. Most of the rural people in India reside in more than 5,18,000 villages who are either illiterates, indigent or ignorant of their rights. They have started to look upon the system as a foe and not a friend, which is undoubtedly an unhealthy syndrome in our society. Even in case of urban populace, most of them are ignorant about their rights who are otherwise literates. Our present traditional system of justice is suffering from three main maladies, or we can call them as three important drawbacks. The first, it involves huge and heavy expenses. Secondly, unexpected and unpredictable inordinate delay in disposal of matters. And third, cumbersome and complex procedure followed by the court. In view of the failure to provide easy, cheap and expeditious accessibility, mental barriers are developed amongst many persons to suffer injustice. Under the Act of 1987, the concept of legal aid is substituted by the word legal service. Needless to mention that the legal aid becomes legal services in real sense when it becomes accessible to the subjects and its object, and when they get benefit by taking advantage of impartiality and integrity of the system. It promotes dispensation of socio-economic justice to the deserving indigent who is suffered or injustice done to such persons. The meaning and benefit of Lok Adalat were elaborately explained by the Supreme Court in P.T. Thomas versus Thomas Job. In this case, the Supreme Court stated that the Lok Adalat is an old form of adjudging system prevailed in ancient India, and its validity has not been taken away even in the modern days. The word Lok Adalat means people's court. The term Lok means people, Adalat means court. As a consequence, the word Lok Adalat means the people's court, and this court try to resolve the disputes among the public. This system is based upon Gandhian principles. It is one of the component of alternative dispute resolution, and this Lok Adalat uses the methods which are evolved in alternative dispute resolution. The apex court said that Lok Adalat is good alternative to justice administration. This is a recent strategy for delivering informal, cheap and expeditious justice to common man by way of settlement of disputes which are pending in the courts, and also those which have not yet reached the courts through negotiation, conciliation with the assistance of specially trained and experienced members of a team of conciliators. The court observed that the benefits of Lok Adalat as follows. There is no court fee, and if court fee is already paid, the amount will be refunded if the dispute settled at Lok Adalat according to the rules. The second, the basic feature of Lok Adalat is that it has procedural flexibility and speedy resolution of the disputes. There is no strict application of procedural law like Code of Civil Procedure and Evidence Act while assessing the claims or disputes. The third objective, the third important feature, the parties to the dispute can directly interact with the judges through their counsel, which is not possible in regular court of law. The award by the Lok Adalat is binding on the parties and it has the status of a decree of civil court and it is non-appealable. It removes the delay in the settlement of dispute finally. The important features of the Lok Adalat are shown in the form of a chart. After going through the important features of the Lok Adalat, let us look into the constitution of Legal Service Authority. Like many enactments, the implementation of the Legal Service Authority Act also took a long time. The Act was enacted in the year 1987 but came into force in the year 1995 after many hurdles and amendments to the original enactment. Even in the year 1995, the states were not keen to constitute the legal service authorities for the implementation of this enactment. Such relaxed attitude towards the implementation of the Act forced the Honorable Supreme Court to take strict action against the states which did not constitute legal service authorities. In Supreme Court Legal Services Committee vs. Union of India and others, the Supreme Court issued notice of contempt against all the states except the states of Orissa for non-compliance of its orders in constituting the State Legal Service Committee even after the lapse of 2 years from the date of its order directing all the states to constitute various committees under this Act. Regarding the presiding officer of the State Legal Service Authority, it was held in the case of Supreme Court Bar Association vs. Union of India that the retired judge can be appointed as a chairman of State Legal Service Authority, but only in exceptional circumstances. In some cases, the retired judges discharged their duties as chairman for some time. So, after going through the various aspects of Legal Service Authority Act, now let us look into powers and functions of State Legal Service Authority. Establishing authorities are not sufficient unless we provide powers and functions in discharging their duties under this Act. So, regarding this, let us look into the role played by the judiciary with respect to powers and functions. The Guwahati High Court highlighted the powers and functions of the State Legal Service Authority in the case of All Guwahati Educated Unemployed Hawkers Association vs. All Guwahati Municipal Corporation and others. In this case, it was stated that the powers of the state authority are purely administrative in nature. The provisions in section 6 and 7 do not contemplate delegation of any powers of permanent Lok Adalat under chapter 6A of the Act to any person or to any authority. There is no room for doubt that permanent Lok Adalat is a concept introduced by the Amendment Act of 2002 to deal with and dispose of disputes at pre-litigation stage. Therefore, neither the state authority nor the executive chairman are authorized under the law to nominate the member secretary to invoke and exercise the powers of permanent Lok Adalat under chapter 6A of this Act. The distinctive features between the two setups are the state authority and the permanent Lok Adalat admit no uncertainty or confusion as their objects are independent. A member secretary may have the requisite qualifications to hold the post of chairman of permanent Lok Adalat, but the scheme of the Act does not contemplate appointment of a person to hold both the posts. High Court of Kerala in the case of Forum of Social Justice vs. State of Kerala and another laid down the criteria for recognizing the voluntary organizations for assisting legal services authority. The power of recognizing voluntary as well as non-governmental organizations for rendering legal services in the state is with the help of State Legal Service Authority. Only those voluntary organizations which are recognized by the state legal service authority are entitled for grants given by state legal service authority for rendering fee legal service. The Madras High Court in the case of M.I. Ibrahim Kutti versus Indian Overseas Bank expressed that the need for uniform pattern in dispute resolution by Taluka Legal Services Committee. As per Section 10 subsection 2 of the Act, the district authority shall coordinate the activities of Taluka Legal Service Committee and other legal service committees in the district. For passing award in Lok Adalat, format is adopted either as prescribed by the state legal service authority or by each district legal service authority.